If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andrew Rosenberg. Andy helps families across South Florida protect what they built and avoid surprises that can derail an inheritance. I'm Lisa Mosby, and today we're talking about what happens when you own property in more than one state, whether it's a vacation home up north or a condo here in Florida. The way those properties are titled can make or break your estate plan. So, Andy, why does owning property in more than one state make estate planning more complicated?
Well, hi, Lisa. How are you, first off? You okay?
I'm here in Florida. It's always glorious in Florida, so more than okay.
It's really cold down there this winter, and it's finally a beautiful warm day. So sorry for anyone up north if they're listening. It's probably 80 degrees and sunny right now. So that's why I live here.
Yes, and you probably own property.
Yeah. So people that own, so it's kind of funny because my wife and I talked about this. Do we want to own an investment property? Do we want to own a second property somewhere? Because one of my sisters lives in Georgia, and we used to go to, here's a quick story. So off topic, but that's okay. So my sister lives in Georgia, right near a University of Georgia, and there's a beautiful area there that it's called Lake Oconee. And they have this place called Reynolds Plantation, which is gorgeous, like golf courses and on the lake and everything else. And they had this huge house there, right? This enormous house that they bought that was fully furnished, 6,000 square feet on the water, no one used. So my wife and my kids and I would use it every summer for our vacation home. So we would go there for a week or two. And then when COVID hit, we went there and it was great. And I told my sister, I said, if you ever sell this thing, I got to have rights of first refusal. So they said, Andy, we're going to sell it. And of course, my kids were in the middle of college. And of course, they went to expensive colleges, George Washington University and University of Miami, both private. So I said, Natalie, I can't afford any of this crap, unfortunately, because I got 2 private colleges to pay for. So I can't buy this property. But I really wanted to buy this property. And that would have been a second house for me, and it would have been in Georgia. So I totally get why people want to do it, but I'm glad I didn't do it because now we just travel. We don't have to worry about, we have a second home and I got to go travel there because if we don't go, we're not using it. So now we just travel the world, which is nice too. But if you have a second home, it can be a problem. It can be a big problem because what happens, and I see it all the time living in South Florida, obviously, we have a lot of New Yorkers in the Northeast and Midwest where I'm from. People come down here and they have a second home, a condo in Boca West, or God knows where they're at. And the issue becomes when you pass away, how is it set up? Because if it's set up wrong, we're going to have a problem. We're going to have probate court. But not only are we going to have probate, we're going to have something called an ancillary probate, which is a nightmare. Because what that means is if you have a second house down here in Florida, and let's say you live in New York, and New York's your home. New York is your residency. That's where you claim residence. And you passed away, and you have the house down here in Florida, and it's in your name. Guess what? We're going to have this ancillary probate. There's all types of probates out there, but there's a special probate called an ancillary probate. And it's meant specifically for people that own real estate in another location, not their resident state. So guess what? We're going to have a probate in New York, which is going to be the domiciliary probate. I can hardly pronounce it. It's the main probate. And then you're going to have to get a separate probate just for the real estate of the state where that property is located. And that example we gave was Florida. And so guess what? You're going to have twice the attorney's fees and twice the cost and twice everything, twice the time, everything else. Disaster waiting to happen. That was a long way of answering your question, I think.
Yes, and can you let's clarify ancillary and I can't say that word either. Domiciliary.
I know it's hard to say. It's okay. So if someone is a resident of another state, so in the example we're going to use, they're a resident of Florida. Of New York. They're a resident of New York, but they have a house in Florida too. So wherever your main residence is, that's your domiciliary is probate. You have to have a probate there. And then if you have real estate in different states, every state that you have different real estate located, you're going to have an ancillary probate for each state where you have a property, because property real estate is unique. And because of that, each state requires you to have a probate, if it's in your name alone, to transfer it properly to wherever you want it to go. So you can't just have a probate in Florida, in New York, and handle the Florida real estate. It doesn't work like that, unfortunately. You have to have a main probate, and then you have to open up another probate in the state where that property is located, and that's called an ancillary probate.
Thank you. That's a little clearer. How can creating a Florida trust help avoid having to go through probate in multiple states?
Yeah. Well, it doesn't have to be a Florida trust. So I tell people, listen, if you live in another state, then you need to meet with an attorney in that state that's licensed in what I do, estate planning and elder law planning. And if a revocable trust makes sense, do it. Okay? Set it up. If you live down here in Florida, meet with me and we'll set up the revocable trust if it makes sense. And why does it make sense? This is why. Because if you own a revocable trust, and I'll explain all that process for you in a little bit, Lisa, but if you own the revocable trust and then you do a deed to the property in the other state into the trust, when you pass away, it avoids all probate. There's not going to be a domiciliary probate, and there won't be the need of an ancillary probate. Because, think about it. Let's say that, Lisa, let's say you live in Minnesota. I think that's where you said you're originally from. Is that right?
Correct. Yeah, it's good.
Yeah. Okay. So let's say that's where you live. That's your residence, and you bought a condo down here in Florida. If you died and it's in your name alone, everything in Minnesota and down here in Florida, we're going to have a probate in Minnesota. We're going to have a probate in Florida for the real estate down here. If you own a trust, the trust doesn't die when you die. So it stays alive. And so because of that, there is no probate, because you're technically the real estate's still alive. Because what happens, the purpose of probate is to make sure we transfer something that is in a person's name, the person that passed away, called the decedent, the person that died, whatever they had, the goal is to transfer it from their name to wherever you want it to go. That's probate. And you got to go through that legal process. The problem with probate is that it takes time, it's expensive, and it's public record. But you got to go through that process of transferring from someone that passed away and making sure it goes to wherever it needs to go, those assets. If you have a trust, the trust never dies, so there's no probate.
Andy, if their homes are both in the trust, are there differences in state laws like homestead rules or maybe community property laws that can affect how the property transfers, or does that go out the window once the properties are in the trust?
Yeah, no, that absolutely takes effects and is important. And that's a whole nother topic that we're going to discuss in another episode here. But the general answer is that if you have homestead, I'm going to use Florida as an example. I'm a Florida resident. I have a trust. I put my house down here in the name of the trust. Okay. Florida homestead rules still need to apply. So if I have an example, Florida, if you are married and or you have minor children, you cannot give your homestead property away to a friend or whatever. It has to go to the spouse and also the minor children. And that would apply if you have a trust or you don't have a trust. So the homestead rules trump the trust rules, if that makes sense.
So follow up on that question. If a couple owns property jointly in another state, does that automatically keep it out of probate in Florida?
So it depends. Everything depends on how assets are titled. So you asked this question. If a couple owns a property as joint tenancy in another state, does that avoid probate court, right? That's what you asked.
In Florida, correct.
In Florida. And the answer is it depends, but probably not. Okay? So the answer is as follows. There's 2 steps to a trust. That's what you need to understand. And we're talking about a revocable trust, which means you can change it, you can amend it, you can do whatever you want to your document. until you die. When you die, at that point, bam, it becomes irrevocable and can't be changed. So up until then, we can make changes to it. But there's 2 steps to this. Number 1, you have to sign it, you have to witness it, you have to notarize. We have to create the trust. That is step 1. At that point, if you're seeing me on the YouTube channel, whatever, we have this empty box, okay? Step 2 is you got to fund or populate the trust, fancy legal term, to fill up the box with assets. Anything that's in the box when you die avoids probate court. That's the purpose of the trust, and will go like your will. The trust says it goes to your kids or however you want it to go. But your question, so that's how the trust works. 2 steps: create it, fill it up. Got it? Your question was as follows: if I have a trust in Florida and I own an asset or real estate in another state as joint tenancy, does that avoid the courts? And my answer is, in that situation, it would be no. Here's why.
No.
Joint tenancy, how is that asset titled? What you just described, you had a property in another state. It's in joint name with your spouse, as an example. Joint tenancy does not avoid probate, guys. It delays it. So when the first spouse dies, no probate. It goes automatically to the survivor. Make sense? Yes? Did that make sense? Okay.
Yes.
Now the survivor's name alone. The survivor dies. Probate. Because it's in the person's name alone. It's not in the box. It's in their individual name. It's got to go through probate up there, wherever it is. And then what we follow the will or whatever they have, and then it goes to however it goes. Now, if the asset up in the other state was in the trust name, then the answer is yes, it would avoid probate.
And then what if we're talking about snowbirds? So typically that means they own a house and that's their primary domicile or primary residence in another state, and they come to the southern states where it's warmer. How does moving to Florida full time change what needs to update in their estate plan?
So here's the answer. And I tell this I do a lot of workshops, Lisa, live workshops. That question comes up all the time. Here's the answer. The answer is as follows. I don't care where you're from. I don't care if you come from New York, New Jersey, Minnesota, Indiana, where I'm from, etc. And you come down here to Florida and you become a Florida resident. You now are a Florida resident. You need to redo your documents. You need to redo them to the state of your residency. There are state-specific laws regarding healthcare surrogates, durable power of attorneys, etc., that needs to be reviewed by someone like me, and they probably are going to need to redo them to the Florida standards. That same concept applies I have clients that start here in Florida, and I've done their documents, and I just had someone move to the state of Washington. And I told her, I said, when you go to the state of Washington, you need to meet with a state of Washington estate planning attorney, because they're going to redo your documents. You need to comply with whatever state you're in. So did that answer your question?
It does. It does. So you just need to update it.
But it's different though. So let's say you're a resident up in New York and you come down here as a snowbird in Florida, and you get in the hospital or whatever, and you got a New York durable power of attorney and New York healthcare surrogate or whatever, that will work. Okay. So the documents that you have will still work if you're visiting somewhere. They'll still work. Okay. They should still work. No problem. But once you move to another state and make that your primary state, you need to redo documents and meet with someone like me to make sure everything is perfect, because every state has unique laws and circumstances with all these documents.
Do you have an example, like a live example of where an out-of-state property caused unnecessary delays or costs because the plan wasn't updated?
Yes. So let's say I have a client that moved down here. They went and wanted to do something to mom's bank account. Mom moved out of state. Okay, so now my client, the daughter, is a client of Florida. Okay, she has Florida documents, so she's fine. But mom's documents are Florida documents, but they know that she moved to another state. So the bank said, we need to see the new state documents because we're not going to honor this because we don't think it's valid, because she's not a resident of the state anymore. And we know she moved. You told us she moved, and you said she had other documents. We don't know if it's valid or not. And it gets really complicated, but I'm going to give you a great story about Florida. And I don't want to bore the crap out of you, but bear with me. The durable power of attorney, which I have a book out there, guys, called If You Don't Plan, You're Stupid. That's the name of the book. Okay. I have one chapter in there, and it's called The Most Important Tool in Your Arsenal. And it's the durable power of attorney. And I want to tell you why it makes what changed in Florida. And this will help you. Okay. Explain what your question was. Before 2011, Florida had something called a springing durable power of attorney. And what that meant is, the durable power of attorney, by the way, is meant for the situation where, God forbid, you become disabled or incapacitated and you can't handle your financial stuff. If you don't have a power of attorney in place, you're going to go through guardianship court. You remember Britney Spears in California and her father and the court system? They called it conservatorship out there, and the whole fiasco, and he absconded the funds and all that crap. You remember all that? That's a guardianship. Britney Spears was over 18. She was mentally unstable. They felt like she couldn't handle financial affairs. She didn't have a durable power in place. They had to go to court. The court named her dad to be in charge, and then her dad did some crazy things with the money. And then it was a humongous battle. We don't want that. That's what's the purpose of the durable power. If, God forbid, Britney in that situation was disabled or incapacitated and she had a durable power, then we wouldn't have had the court. And then the person she named could just handle things. Florida, in 2011, before 2011, Florida had something called a springing durable power of attorney. What that meant was the durable power of attorney didn't spring to life and work until you had two doctors stating that you're disabled. And then whoever you named as your power of attorney could use it. The problem was, and this is, I think, a roundabout way getting to your question and answer. The problem was the banks and all these brokerage accounts and financial institutions said, whoa, this is too hard on us, too much onerous on us. We have to get doctors' notes showing that they're disabled to know that durable power is working. So in 2011, there's a strong lobby with the banking lobby and the investment lobby. They lobbied the Florida legislature, and Florida legislature in 2011 got rid of the springing power of attorney and created a regular, general, durable power of attorney. The difference? Once we signed the durable power of attorney after 2011, it's up and running now, and it continues to work if you're disabled or incapacitated. Big difference, right? Now the banks just don't care and they'll honor things. Well, the issue was before 2011 with that springing one, the banks wouldn't honor anything unless you show you have notes and everything else, right? Now they can honor anything. The problem is they can still dishonor your durable power of attorney. They can say, we don't like it. Even though it's signed in a witness. And they're legally allowed to say, no, we're not going to honor this. The issue is, if they don't honor it, they have to give a valid reason for it. And they have to prove it. And if you go back and you say that is not valid and they still won't honor it, you can sue them for attorney's fees and everything else. But the point is, it's a complex situation when it comes to going to these institutions and you have these documents, a doctor's office, etc. They may or may not like these healthcare surrogates or stuff, and because it's out of state or it's in state. So all this stuff matters. So the answer to your question is, you need to continuously update your legal documents and estate planning documents and meet with someone every year or two just to make sure everything's in place and it's valid, because laws change and things change and people move. Did that answer all this, or did I just waste everybody's time?
No, I think you did a really good job of it. And the answer is update your documents. It doesn't matter where you're going. If you're moving into Florida, out of Florida, if you're coming from another state, make sure that your documents are updated. This is my takeaway, and double check every 1 or 2 years, because circumstances change, things about our families change. And to really be protected, they need to reach out to you and make sure they update their documents. Did I sum it up well?
Yes. Yes, you did. And the third takeaway is for those people that are snowbirds, if you have real estate in other states, you probably need a trust, and you probably need to make sure the deed says that it's in the trust so that you avoid that ancillary probate if that ever happens.
Perfect. Folks, thanks so much for tuning in to today's episode of If You Don't Plan, You're Stupid with Andy. Owning a home in different states doesn't have to mean multiple probates or legal problems. If you're a Florida resident or a snowbird with out-of-state property, visit rosenberglawfirm.net to make sure that your plan covers every home you own, no matter where it's located. And don't forget to like, review, and subscribe so you don't miss the next episode. We'll see you there.
Thanks, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.